Hey, everybody. Welcome. I missed you last week. I had a great weekend with my daughter for her birthday, and it was well worth traveling on Wednesday, but I missed being with all of you too. So, how are you tonight? Boy, do we have a lot to talk about. We have two big things to talk about. First of all, we need to talk about Lori Vallow and her appeal, and then of course we need to talk about the Murdoch case and the motions for new trial. But you all asked me to look up and talk about a couple of other cases. So I thought I'd jump into those first, and then we'll end up with Lori and Alex. Several people asked me about Richard Allen and the Delphi case, and it doesn't look like much of anything is going on in that case. I know that there has been a trial date set, and I know that in April there was information released that he had confessed to the murders to his wife on a recorded jail phone call. But we haven't heard much since then. We know that his health has been poor, so we don't know whether that has anything to do with it, or whether there's some sort of behind the scenes negotiation going on to see if they can resolve the case. It certainly is more likely that it will resolve now that this information has come out about his confession. If anybody else has any updated information on it, be sure and post it in the chat, and Michelle get it pulled up. But right now, the only thing I find is that he is still in jail awaiting trial. I also looked up Dylan Rounds. It looks like nothing new has happened with his case either. You may recall he was a young man who disappeared while dry farming out in Utah. And a person has been arrested in his murder. That's the one where they found his cell phone, and it had a recording on it that looks pretty damning. But his body hasn't been found, and I think the prosecutors would definitely prefer to have a body before they prosecute. Some of you asked about Patricia Betts, Batts with an A, Betts, out of West Yellowstone. It's kind of an interesting case. I think it will be interesting to see what may develop later out of the case. But for now, what we know is that Patricia Betts, her husband, and two of her children were prosecuted for the deliberate homicide of her grandson, whose name is... I was sure I wrote it down because I always write down the victims' names. Her grandson was beaten, and apparently beaten to the point of his death. And her charges had to do with her creating an environment where her son, who was a young adult, I believe, could beat the boy without repercussions, and that she didn't seek medical attention for him, and then told her son and daughter to lie. It's a terrible case, and it has awful facts. The other case that I wanted to talk about before we dig into Murdoch and Vallow is Ruby Frank. It's very interesting. I was listening to an episode of Mormon Stories, and I will post the link in our story, in our show notes after we're done here, because it was focusing on the Mormon connection, on the LDS connection with Ruby Frank. Ruby Frank was a mommy blogger, an LDS mommy blogger, who has now been arrested for child abuse after 2 of her children were found emaciated and malnourished and restrained with duct tape. She has been one of those bloggers who has espoused the idea that parenting needs to be done more strictly and that children need to be held accountable. She's the mom who wants her children to go hungry if her 6-year-old daughter forgets to pack her lunch. She's the mom who penalized her youngest children by telling them they wouldn't be receiving a visit from Santa because they were too selfish. She's the mom who happily waits to take her children to the emergency room and makes them wait and be more patient even though they are ill. All of these things are supposed to teach natural consequences, and they're all sort of designed to, in a sort of spare the rod, spoil the child philosophy. So it's very interesting. She got involved with another woman whose name is Jody. I can't think of her last name right now, who is a licensed therapist, and they teamed up to give parenting advice and therapeutic advice and run groups and group therapy and those sorts of things, all espousing this philosophy, if you can call it that. Hildebrand, thank you, Arizona. I knew somebody'd come up with it. Jody Hildebrand. She has been in trouble with the ethics board because of her misuse of confidential information. She has been accused of using the information that she received while in a doctor-patient relationship and releasing that information, excuse me, to both the person's bishop as well as their faculty at BYU, resulting in them being expelled from BYU. So she is not a great role model to begin with, and now she's teamed up with Ruby Frank, and they are definitely a pair to draw to. So it will be interesting to see. What I thought was really interesting was John DeLynn, who is a doctor of psychology, who is the host of Mormon Stories, was drawing some parallels between some of their behavior and the Vallow case, which I thought was pretty interesting. So I'll drop the link in the show notes if anybody is interested. Yes, I am losing my voice again. It is just, it's been raining outside, and that kicks up a lot of stuff in the air. And I'm going to try my best to keep drinking water and keep my voice. It just started kicking in around dinner time, and I thought, oh, great. Now's the greatest time on Wednesday night for me to have voice problems, but there's nothing I can do about it. This is me medicated for allergies, and so there's not much more I can do about it except apologize and ask you to bear with me. So the biggest news to come out of, and for those of you who got a newsletter yesterday, we did a bit of a deep dive into the Lori Vallow notice of appeal. Lori Vallow listed 16 different issues that she believed would justify a new trial on her appeal. So I did go through those in depth, but I do want to talk about a few of those things that I think are probably the most likely to potentially get her a new trial. We've talked before about the fact that the court violated her speedy trial right. The court acknowledged at the time that he set the hearing in April that they were 41 days past her speedy trial window. So we know that the courts take speedy trial very seriously, and that of all of the issues that were brought up during the trial, I believe this one is the one that may very well get her new trial, if any of them do. I think that it's a rather a close call at this point, but it will depend on what the Idaho Supreme Court thinks about it. Because what the judge said was, yes, I realize that we're violating her speedy trial right by 41 days. However, there is good cause. The Supreme Court is going to have to decide whether there is good cause or not. Now, the two things that happened that led them to reset that January hearing were primarily that her counsel had asked for a new evaluation for her because they believed she wasn't competent. Now, the judge kind of jumped the gun a little bit because the evaluations and the determination that she was still competent came back in time for them to keep that January court date. But it did leave a lot of uncertainty ahead of that January court date about whether or not the trial was going to happen. By the time that that determination was made, it was well into November, and that it would have been difficult for everybody to get up and running in time. So the judge found that there was good cause to set it beyond her trial date. The other reason he found that there was good cause was because it was an out-of-county change of venue trial, and that that they would have to seek accommodation from Ada County, the jurisdiction where the trial happened. So he went through that analysis and decided that there was good cause for him to set that trial into the next year and beyond Lori's speedy trial window. The defense also said that they believed that it was wrong for the court to decline to. I'm sorry, I was just doing something on my computer here. The defense also claimed that it was wrong for the court to decline to recommit Lori after there was so much proof of her mental health issues. That is a tough thing because on one hand, they didn't bring forward any of those mental health issues in the trial. So it's hard on one hand for them to say she should get a new trial because she wasn't competent. But oh, by the way, on the other hand, we're not going to press that issue because Lori doesn't want it. So it was that one's a little bit of a stretch. So interesting to find out what the Supreme Court is going to say about that issue. There were some other additional grounds for her notice of appeal. One of them had to do with the fact that the court allowed the prosecution to amend the indictment in the middle of trial. And so it will be interesting to see if any of those issues gain traction with the Supreme Court. So let's talk a little bit about what happens now. The defense has asked, because some of their grounds for appeal are based on things that happen pre-trial, in pre-trial hearings, they have asked for a complete transcript of all of the hearings, pre-trial and trial. So we know we had a 6-week trial. We know we had hours of pretrial motions. So we know that that is going to take a substantial amount of time for them to create those transcripts. What happens is the court reporter, or the transcriptionist, let me put it that way, sits down with the recordings, any writings, and they literally go word by word through the transcript and transcribe it into written form. It also, the transcriptionist also has to be someone who is court certified, and there is a process for how the transcriptionist certifies their transcriptions. That means that they have to go through and review every one of those, they have to go back and check and double check each one of their sections that they transcribe. If that sounds like it's very labor intensive, it is. It takes months, years sometimes to get a full transcript done. Once that transcript is complete, then the defense is going to have a certain amount of time, usually 60 days, depends on the jurisdiction, to draft their initial appellate brief, laying out all the issues, their argument for why the trial court got it wrong, and all of their research that backs that up. They will very likely ask for extensions on that and get it because of the voluminous nature of the transcript. Now, remember, appeals can only be brought on things that the defense objected to at the trial. You can't bring up a new basis for an appeal if you didn't bring it up at trial. So they are limited to the things that they objected to during the trial. But there were plenty of those things. And the primary things that they objected to were the lack of speedy trial, the prosecution's asking for extra time, the discovery issues, the issues surrounding the amendment of the indictment, all of those things. Those were all things that were objected to by the defense, and they come up on appeal. Now, the one thing that that does not have to come up on appeal is ineffective assistance of counsel, because no lawyer's ever going to raise that. Well, I won't say no lawyer will, but most lawyers don't. And so that issue will have to be raised by the appellate attorney if they believe that there was ineffective assistance of counsel. Now, I want to talk a little bit about ineffective assistance of counsel, because a lot of people have this question. So, yes, your attorney can make tactical decisions about how not to, or how to pursue the case. The defendant can also make those tactical decisions. And so in this case, Lori Vallow decided that she did not want to pursue the mental health issue during trial. She also decided that she did not want to pursue any sort of some other guy did it defense that would have implicated Chad or her brother Alex. I don't think Chad is going to be that nice about things. He is not going to be that generous, but she was. And so the problem then becomes for the Supreme Court to say, okay, you didn't bring these things up during the trial. We can't address them. However, they can address any sort of claim of ineffective assistance of counsel. But a claim for ineffective assistance of counsel requires that their counsel be so bad, the representation be so bad, that the outcome would have been different had they had better representation. Now, if you recall, in the Jodi Arias case, she filed an ineffective assistance of counsel appeal, and it was denied because the court said, regardless of whether your lawyers participated or slept through the trial, there was sufficient evidence brought in by the prosecutor to support a guilty plea. So it falls under the heading of no harm, no foul. So I think in this case, it will be difficult for them to get an ineffective assistance of counsel finding. I still think that probably the best chance they have of any sort of new trial from the appellate court is going to be the speedy trial issue. And I think it's going to be difficult because the Supreme Court is going to have to look at what delay was attributable to the prosecution or the state, what delay was attributable to the defense, and what delay was simply unavoidable because she wasn't competent. And I think that the court is going to have to really just sit down and pencil out what that looks like, how many days it was, and then look at whether or not that amount of time was prejudicial to Lori. And on the flip side, whether or not the court found there was good cause to exceed the speedy trial limit. Some of the things we don't know because we weren't involved and these issues weren't televised is we don't know what discussion was held when Lori was found competent the second time. We don't know what kind of discussions the court had with the prosecution and the defense about whether or not Ada County was going to have a courtroom available and time available in order to make this trial happen. So those are things we don't know, but I'm certain they will be included in Lori's appeal. And we may learn new things in Lori's appeal. Now, we still have Chad's trial coming up. We haven't heard a peep out of John Pryor. We haven't heard a peep out of anybody involved in that trial. So we really don't know what to expect. We know that Lori has been, that Arizona has asked for Lori to be extradited. The Arizona governor signed the governor's warrant as soon as it got to her desk. And the Arizona officials are saying, we've been waiting a long time to prosecute this case and we're ready. So send her over. What we don't know is what state of Idaho has done about that so far. So we're waiting to find out what is going to happen, whether she's going to waive extradition or whether she will fight extradition. The only thing that she can do in fighting extradition is say, I am not the Lori Vallow on the warrant, or the Lori Vallow Daybell, or however they have her identified. And then the state of Idaho would have to hold an identity hearing and determine whether or not she is in fact the Lori Vallow that Arizona is seeking. That is the only thing that she can do to slow down the extradition process. And we can talk, and we have talked before about how very unpleasant it may be for her to be transported. You might recall that when she came back from Hawaii, she came back with 2 detectives or 2 members of the local law enforcement who escorted her back, and she flew back on a commercial airliner. When she landed in Boise, the governor of Idaho sent the state plane, which is under his command, to pick her up and fly her from Boise over to Rexburg. Now, I'm not faulting the governor or Idaho or Hawaii for any of that. It made perfect sense to get her back to Idaho in the most expeditious way possible. It wasn't possible. The only way to get her back from Hawaii was to fly. So I do understand why that was done. But as a convicted prisoner at this point, as a convicted murderer, she will get on the prison bus with everybody else. And those of you who've ever seen The Fugitive or Con Air, that's what jail buses, prison buses look like. They are not fancy motor coaches. They are uncomfortable, old school buses, and they stop at every little podunk jail and every prison on a circuit all over the West Coast. So if you happen to get on the bus at the end of the circuit, you could be riding the circuit for weeks. And it's terrible. They're housed at local jails and prisons in temporary housing. That means that every time they get off the bus, they've got to be strip searched, they have to be processed, and it is really onerous, and it is no fun. And so that will be the trip that she has in store going from Idaho to Arizona. But we don't know when that will happen because we don't know when the Idaho will finally release her under the Arizona governor's warrant. So we're just waiting to find out what that's going to look like. If she waives extradition, she could go right away. But I don't know that Idaho is in a real big hurry to send her, but she's already been sentenced here, and we'll have to wait and find out when she gets released. Now, the big, juicy, super juicy development in the Murdoch case. Last week we heard, last week, Thursday maybe, we heard that Dick Harpootlian and Jim Griffin, Alec Murdaugh's lawyers, were filing a motion for a new trial, claiming that new evidence had been discovered. And usually that means that there is a new witness or there is new physical evidence. It is surprising when we find out what the actual new evidence is. So yesterday, they had a press conference and announced that they were seeking a new trial for Alec Murdaugh because Becky Hill, who is the clerk of the court and was running the courtroom during Murdaugh's trial, had improperly had contact with the jury and may have influenced the jury's decision. This is huge if it is true. If it is true. Now, we know, those of us who have been following the Murdaugh trial for a long time, those of us who follow True Sunlight and Mandy Matney, we all know that South Carolina has been notoriously corrupt. And the government and agencies within South Carolina are pretty notorious for their level of corruption. However, the allegation is that the clerk of the court made statements to the jury that, if the jury believed them, would clearly have impacted their decision. She also is alleged to have done some things that put pressure on the jury, such as telling the 6 smokers that were on the jury that they couldn't smoke until after they reached a verdict. This was particularly difficult because the whole time they had been hearing the case, they had been allowed to take breaks and smoke. So there was a lot going on. She is alleged to have told them, don't be misled by him and his antics on the stand. Don't believe what you're seeing. And in other ways, once the case went to the jury, telling the jury, you should be able to wrap this up quickly, telling the jury, if you don't reach a verdict tonight, you will be taken to a hotel tonight. When the jurors didn't know that, they weren't prepared, they didn't have changes of clothing or anything that they needed. So there were, if any of those things are true, that is perhaps subtle but clear jury tampering. It is trying to influence the outcome of the case. Now, Murdoch's lawyers contend that it was because she wanted to write a book. Their motion says she had a book deal. It's come out since that she did not have a book deal, that she had been keeping a journal and keeping notes and thinking about writing a book about the case, but she did not have a book deal. However, after the trial was over and she got plenty of time on the Today Show, I think, a person approached her and they wrote this book together. They wrote it really fast, 4 months. They self-published it. So the defense team claims that she influenced the jury because she wanted a guilty verdict, because a guilty verdict played better in her book, and that she had a book deal. She did not have a book deal. And in fact, her co-author and she put their own money in to self-publish the book. A substantial amount of money. They, according to the co-author, they split and put in $30,000 to pay for printing and to the self-publishing process. So that's a big investment out of their pocket. And they didn't have a deal with a publisher for a book advance or any of those things. They were strictly going by self-publishing. Her co-author is a journalist who is local to South Carolina and was interviewed today on Court TV, I believe. Yeah, Court TV. So you may want to go and take a look at that. Now, there are a lot of people who are saying Dick Harpootlian and Jim Griffith have been known to stretch the truth and to embroider the truth before. And there are a lot of people who find this very suspicious. I think what I'll say is, if a single one of those allegations is found to be believable, then I think Alec Murdoch gets a new trial. It is that serious a breach for a government employee, the clerk of the court, whose responsibility it is to assure that the court runs smoothly and that it runs fairly, that juries are protected, that they're not influenced. It is so important, and it is so outrageous to think that the clerk of the court could be in that position, that if it's true, I think Alec Murdoch gets a new trial. I don't know whether it's true or not, because we haven't seen the evidence either. Now, what Harpootlian and Jim Griffith say at this point is they're entitled to have an evidentiary hearing. And at that evidentiary hearing, they're entitled to call witnesses to put on evidence to show that what they're saying is true. I just saw a comment in the chat, and I'm just going to pull it out right now. However, the jurors who were there all signed daily affirmations saying that they had not been yeah, I heard about this too. All of the jurors signed daily affirmations saying that they had not been approached by anyone, that they had not been unduly influenced, all of those statements that jurors sign every day when they take the jury box. So now we have juror. Additionally, the defense asked to have the jury polled, and the jurors, all of the jurors, were asked whether or not that was their true verdict, and they said that it was. So it's interesting to see. It'll be interesting to see what sort of evidence they have. It would be tragic to think that Dick Harpootlian and Jim Griffith, who are officers of the court, would make these kind of allegations against another officer of the court if it weren't true. If these allegations are not true, I think she has a very good libel and slander case. So it would surprise me if it wouldn't surprise me if they had started a whisper campaign about her. But to this blatantly and clearly, full-throatedly accuse her makes me wonder if there's some smoke where this fire has happened. So I did see that the attorney that has come forward to represent the jurors is someone who is a close friend and former partner of Pootie, Dick Harpootlian. So I do understand it is a small community, and they are very, everyone is very entwined. So it doesn't surprise me to find out that the lawyer who's representing these jurors is somebody who has history with Dick Harpootlian. So it's going to be really interesting to see how this develops. I am hoping that they are going to set an evidentiary hearing as soon as possible and put this either Judge Newman is going to rule that it is true, or Judge Newman is going to throw it out. But one way or the other, it's going to be dealt with, and it's not going to hang around for weeks and months. So I am hoping that that it won't take too much time before that happens. It's going to be very interesting because, and I know that you've all had the opportunity to go online and to see other creators, other lawyers talking about a client's Sixth Amendment right to fair trial and a client's right to due process, and that this clearly is a violation. I'm sure that you guys have all had a you're right, it is Jim Griffin and not Griffith. For some reason, I get those twisted. I think you've probably all had the opportunity at this point to understand why it is such a big deal. We like to believe that our Constitution protects both the guilty and the innocent from the abuse of power. And what that means is that the government cannot prosecute someone without proof. They can't hold someone indefinitely without charge. That person is entitled to representation. They cannot go into someone's house and ransack it and seize property without a warrant. They can't arrest you without probable cause. All of those are safeguards for both the guilty and the innocent. And so it is important to assure that the process is fair and the process is squeaky clean. So if there is some appearance of impropriety, then the judge needs to get to the bottom of it. And Judge Newman will decide whether or not it is sufficient to order a new trial. Now, what the case law says is it is impossible at this point to go to a juror and say to that juror, were you influenced by that? It's kind of like unringing the bell or closing the barn door after the cows have escaped. So it's going to be very difficult to prove that there was actual, that there may have been a juror that was actually persuaded by what happened, by her comments. So what the Supreme Court says is if it is possible, if there's any possibility that a juror could have been influenced improperly by a comment made by the clerk of the court, he should get a new trial. So it's not just looking at the evidence and saying, did she do it? Because even if there's a doubt about whether or not it had an impact on the jury, the judge is required to err on the side of giving them the benefit of the doubt. I see that there are a ton of questions, so I want to try and get to as many of them as possible tonight. So let's dive into questions. Hi, Mary. How can the courts keep shoving the Pootie case to the front when there are so many other folks waiting for just a trial date? This is a good question. So just like Lori Vallow was entitled to a speedy trial, Alec Murdoch was entitled to a speedy trial, and he also did not waive his right to a speedy trial, which meant that he had to be tried within the statutory time limit. Now, as it applies to an evidentiary hearing, the court will have to set that. I'm a little concerned that there may very well be some other looming deadlines that could impact it. Not the least of which is South Carolina has a mandatory retirement age for judges. And I think Judge Newman is bumping up against that. Now, for the sake of efficiency, they're probably going to want Judge Newman to hear any kind of an evidentiary hearing. So it would make sense for them to try and get that on his docket as soon as possible. If Alec Murdoch is ordered to have a new trial, he's once again going to be in custody, and his trial will take precedent over anybody who's out of custody. That's just the way it works because of the speedy trial rules. So, but good question. This is not, it is not exclusive to South Carolina. All states grapple with this issue of how to prioritize cases. And I'm telling you, some of the biggest frustration is the court will set 3 or 4 trials all on the same day, because they know that percentage-wise, at least some of them are going to resolve before trial starts. And there's nothing more frustrating than to try and get on a trial docket, and you're waiting and waiting and waiting. You finally get on the trial docket, and then the trial court comes up and says, sorry, I have an older case that bumps you because the case ahead of you didn't settle. Or you're fighting to get on a court's docket, and you walk in the courthouse and every courtroom's dark because everything for that day settled. Court scheduling is more like water witching than it is like an exact science. I'm here to tell you, it's like getting the Ouija board out. So it is frustrating sometimes for both the court and the lawyers and the defendants when they can't seem to get a decent trial date. And I agree that sometimes, at least, you have the appearance that people are getting priority. I can't say in South Carolina in particular whether they are getting bumped to the front of the line or not. I do know that he didn't waive his speedy trial and that they set his trial toward the end of his speedy trial window. So good questions. I love Judge Newman too. I think he is a very admirable man. I think that he was very even-handed in the way that he dealt with the trial, and I think he was very impressive. And I thought to myself, he's a judge I'd really like to appear in front of. Hi, Mandy. Yes. I'm from the Low Country, and it's more likely that Dick and Jim got a few people and some money and paid them for an affidavit. Couldn't get to the jury before, but could get to them after. Well, you know, it is not, jury tampering is not super common, but it does happen. And I'm not going to tell you it doesn't. So I am disappointed to think that two officers of the court would perpetrate this kind of a fraud on the court and would ruin the reputation of a well-respected colleague if they didn't have something to back it up. It's not outside of the realm of possibility. I'm sure that there were a lot of people who had a really hard time believing Alec Murdoch, who was a pillar of the community, stole millions of dollars from his clients. So I'm not foolish enough to say that it's outside the realm of possibility. But I will say that two sworn officers of the court blemishing the reputation of a colleague for a client would be shocking. So, not that it doesn't happen or couldn't, but I would find that more shocking than that she actually made comments to the jury, which I find shocking enough as it is. Hi, Jenny Meow Meow. They are serious allegations. What evidence would they need to prove it? Now, here is an interesting discussion to have. What is the standard of proof? I know that's not quite what you asked, but I think that gets to the heart of the question. Do they have to prove beyond a reasonable doubt that she committed this act? They don't. The legal standard is going to be a preponderance of the evidence. So the judge is going to have to decide. Now, I could be wrong. It could be different in South Carolina, but nothing I've seen so far says that an evidentiary hearing would would have a higher standard of proof. So if anybody else, if you know that I'm getting it wrong, please let me know. But at this point, an evidentiary hearing, the judge just has to be persuaded, more likely than not, that it occurred. It's the same, an evidentiary hearing is typically a preliminary matter. In this case, it would be a post-trial matter, but still, the judge is going to have to make those determinations based on the credibility of the jurors. So it's a lot to think about. And I will say, Joe Kelly just said 4 witnesses, that's proof. I will say that according to the Dick and Jim show, they interviewed and discussed with these jurors separately and heard their stories and obtained their affidavits without discussing what anyone else might have been saying. I don't know whether that's true or not, but I do know that the more witnesses that you have, the better. And even if they're wrong that she had a motive or that was being self-serving about to further her own career and her 15 minutes of fame. Even if that's not the case, we still are left with, did this happen? And is there a chance that a juror was persuaded by those comments? So it's going to be a lot for Judge Newman to think through and to research and to read prior to having an evidentiary hearing. Julie, do these jurors that provided affidavits face possible perjury charges since this was not brought to the court's attention during the trial? Well, that was where I was going with the fact that these jurors signed their juror affidavits every morning saying that they had not been influenced in any way by anyone other than the evidence that was coming in at trial. Now, I mean, I think that the defense can argue that it didn't happen until the real blatant stuff didn't really happen until the case went to the jury and they were charged with deliberating. So, I mean, I think it's possible that if there is clear evidence that jurors knew that somebody was trying to influence them and didn't say anything, it's possible because they signed sworn statements saying that they had not had any contact with anyone who could have tried to influence them. On the other hand, I think the defense can argue that the bulk of those persuasive comments didn't come until after they got the case and retired to the jury room. So, then you can ask, well, when you went around the room and polled the jury and each one of the jurors said, yes, this is my considered opinion, that was a sworn statement too. So there are a lot of tentacles in this. There are a lot of issues to look at, a lot of things that could be a problem for both sides. Susie, if these allegations are found to be true, what could it mean for other cases in this court? Well, that's a good question. I think that that the state is going to argue that even if she made those kind of comments, it was a high-profile case. Everybody was under a lot of pressure. It wasn't your typical case, and that it's more likely that she would make those sort of comments in that case than in other run-of-the-mill cases. But I think that defense attorneys will very likely, in other cases that have been tried in front of with her as the clerk of the court, they'd be foolish if they didn't raise that and say, I had a jury trial and this clerk of the court was taking care of the jury in my case, and how can I be sure that she didn't do the same thing in my case? There have been a couple of similar kinds of cases. When I was in Oregon, we had a person who was in the state crime lab, and the crime lab got kind of overworked, and this person started falsifying results from testing because they didn't have time to do the testing the way they were supposed to. And when it was discovered that this person was falsifying test results, there were hundreds of cases that had to be reopened. It was a nightmare because guilty pleas, people had entered guilty pleas because the evidence had shown positive for, you know, the stuff they took out of your pocket was really methamphetamine, or you know, the DNA showed it was you. And so there were hundreds of cases that had to be reopened, retested, and re-examined, and in some cases retried because of that. And I think it's possible we could be seeing something similar looming in that county. Now, my understanding is that it's a small jurisdiction, and you may not have as many jury trial cases as you would expect in a bigger jurisdiction, but still, I think it's a concern. And defense attorneys, it would probably be malpractice for them not to raise it, if in fact these allegations do prove to be true. Good questions tonight, guys. You don't ask the easy ones. Hi, Janine. I hope you and Clint are doing well. I haven't had a chance to visit with you in forever, but I hope you're all doing well. I see your Facebook posts. Looks like your family had a good summer. Let's see, Janine, it's so sad that a court clerk could allegedly get up in the notoriety of a high-profile case and risk losing her career and possibly getting charges herself. Well, I agree completely, and that just definitely weighs on the side of this is foolish. Who would do that? So it definitely sort of weighs on that side of who in their right mind would put their reputation and their job and their and everything, their reason for getting up in the morning, who would put that on the line to influence a jury? So, I mean, it's a good question, and I think that's certainly what the state's going to argue. This is a woman with a lifelong elected county official. This is a person who is a career servant, civil servant, community servant. Why in the world would she risk that sort of notoriety? Why in the world would she risk someone bringing it to the court's attention? It doesn't make sense. So, you know, I mean, we're really still in such an early stage that it doesn't make sense on either side. It doesn't make sense for two lawyers who are officers of the court to accuse a third officer of the court of something so heinous. And yet it doesn't make sense for the clerk of the court to put everything on the line to make these kinds of comments. So somebody's right. We just don't know who's right yet. So it's going to be very interesting to see how this plays out. Michelle just pointed out in the chat, wristbands are still available if you would like to get Justice for Tylee and JJ wristbands. They're still available. You can send me a self-addressed stamped envelope. I have a few here that I haven't processed, so if you sent me one recently, it's likely that it needs to go out in the mail in the next week or so. Please do send them. The address is on the screen. It's also in our show notes. They're absolutely free. All you need to do is send me a stamped envelope and I will send one to you. Remember, we still have Chad's trial coming up. And so we're not giving up on getting justice for Tylee and JJ yet until they receive justice completely. Thank you, Julie Fitzgerald. I love listening to lawyers discuss our judicial system. Well, if you all have been following me for a while, you know that it is something that I am incredibly passionate about. I really have always believed that it is our criminal justice system that sets us apart from a lot of other countries and certainly from a lot of totalitarian regimes. The fact that we protect people's rights, whether you are guilty or whether you are innocent, is, in my mind, one of the most important rights that we have. So, y'all know I'm passionate about it. And as I say, we don't know enough to know who's telling the truth yet. And this is a situation that is really unique. We have two officers, sworn officers of the court, who've taken an oath, and we have one sworn officer of the court who's taken an oath, all of them taken an oath to defend the Constitution, saying one or the other of them is lying. It's going to be very interesting to see how it all finally works out. But I would not be the least bit surprised to see Alec Murdaugh get a new trial. So let's talk about what that looks like. If he gets a new trial, it is as if the first trial didn't happen. So they are free to bring in any newly developed information that may have come out since the first trial concluded. And now they have a preview of the state's case. So that always puts the defense in a better situation. There will be a whole new crop of jurors. None of these jurors would be involved, none of the jurors that found him guilty. And whether or not Judge Newman would rehear it is, I think, going to depend on when his mandatory retirement date comes up. So I think that it is important to keep that in mind, that we hope we're going to see that evidentiary hearing fairly quickly. But it could be months before he gets a new trial. So we could be seeing Alec, we could be seeing the live stream of Murdoch 2.0 here. I did see a question in the chat about whether or not this touches on double jeopardy. And it does not, because what happens is the judge essentially says, because the proper procedures were not followed, I must completely invalidate the prior trial. So it is not double jeopardy, because the court is saying we're going to wipe that trial out because it wasn't right, and we're going to go back and retry it. It is the same as if there is a mistrial because of some violation of the rules. So double jeopardy does not attach in the case where the judge, you get all the way through trial and the court says, we did it wrong. So on one hand, the defendant gets another bite at the apple. On the other hand, the prosecution gets another bite at the apple too, because that's how it's equitable. Hopefully that makes sense. You couldn't say double jeopardy attaches. So sounds like Miss Becky should have saved her money for her own legal defense. Is she still currently employed at the courthouse? What a damn mess. My understanding is that she, and what would likely happen is she would be put on leave while the investigation happens. It would not be appropriate for her to continue to work around the courthouse while the allegations are being investigated. Once she is, if the court says, we don't believe any of this happened, I don't find any of it credible, then she could be reinstated. However, then comes the issue of what does that do to her reputation long term? Even though the judge says, I don't believe any of it happened, there's certainly once again, you can't unring that bell. And people in the community are going to know that she was accused of having influenced juries. So I suspect her career is over, whether she's reinstated or not. And it is a damn mess. Oh, good question. Do I think Alex will testify again? That is going to be tough because he did not do himself any favors the last time. However, his sworn, I know this sounds weird if he's going to get a completely new trial, but anytime you testify in court and your statements are sworn under oath, where the other party has the opportunity to cross-examine, those statements can be used for impeachment purposes in another trial. So even though the judge is saying he gets a new trial, he's not erasing any of the testimony that happened in the old trial. That means that if he gets on the stand and testifies to something different than he did the first time, he could be likely, they could bring that out to impeach him. I would have to think through the rules of evidence and look at the South Carolina Code to know how much of his prior testimony could come in, but certainly it could be used to impeach him. So whether he testifies again or not, some of that testimony could come in. I don't know. I mean, I think his lawyers felt from the beginning like he was damaging his case by testifying, but he's enough of an egomaniac and a narcissist that I think he will think, oh, this time I have the chance to get up there and do it right. So I think better than 50-50 that he'll go back and testify again. Good question. Hi, Jan. How would a new trial affect all of his admissions of the theft of settlement money? See, that was done under oath. And so that all is memorialized in that under oath form. And so it can all be used in his other trials. That's a good question. That's talking about the nuances of how evidence is used. But technically, his federal cases and the state cases on the theft of the money, all of those admissions under oath can come in. So just because his conviction gets thrown out in the murder case does not mean that all of that testimony is invalidated. Interesting little twist, isn't it? Well, we just answered that. No, they can't throw it out. Hi, Lynn. If she did speak with jurors in this manner and the jurors had concerns, would they tell the bailiff? Then the bailiff let the judge know? Or would the clerk of the court be the messenger? This is a good question. In general, and my understanding is the way that the courtroom operated down there was her primary job was to manage the jury, to make sure they were fed, make sure they were comfortable, make sure that they had everything they needed. It was her job to get them in and out of the courtroom. That was all stuff that was done by Becky Hill. The bailiff, and it varies from jurisdiction to jurisdiction. So, for example, in Lori Vallow's case, it was the bailiff who went out and got the jury and brought them in and told the judge that they were all there and was responsible for the movements around the courtroom. When a trial exhibit was handed up to the judge or to a witness, the bailiff picked it up and took it over and delivered it. Every courtroom procedure is different. In a lot of courtrooms, attorneys walk documents around the courtroom, and so there's not that intermediary. But oftentimes the bailiff's primary responsibility is to maintain order in the courtroom. My understanding is that it was Becky Hill's job to be the one who was overseeing the jury and answering jury questions and communicating jury information back to the judge. So you're right, it does make it kind of sticky for a juror to say, by the way, could you ask the judge if it was okay for you to tell me that you didn't think this was going to take long because he's guilty? You can see how awkward that might be. So this is a good question. And I suspect that the jurors didn't have a direct line to the judge other than through Becky Hill, just based on what I saw during the trial. How would the new trial affect all of his admissions on the theft of the settlement? We've answered this, but the answer is that those admissions are preserved and they will be able to be brought in both in the state and the federal cases against him for all the thefts. So these are very nuanced questions tonight, having to do with how the rules of evidence and how we get in. Yay! Hi, Terry. There's my wrong side. There's our beautiful quilt up there. I need to get some borders on it and get the announcement out of how we do the raffle. So stick with me for that. Terry did the long arm quilting on the quilt as well as on my daughter's quilt, and she did an absolutely astonishing job. They're beautiful. So Terry, from now on, you're the only person I'm sending my quilts to. And I'm glad you made a live. Can Lori be extradited to Arizona before a decision is made on the appeal? Absolutely. And it's very likely that she will be. Appeals can take years. It would not at all surprise me if it takes a year and a half to get the opening briefs filed and another year and a half to get any kind of an argument in front of the court scheduled. Because once you get the documents and the information all presented to the court, then they have to schedule oral arguments. They have to schedule a hearing in front of the Supreme Court, and they don't take a lot of cases, and it takes a long time to get in front of them because their schedules are very full. So it is most likely that she will go on to Arizona. She'll be extradited there, answer those charges. Idaho has dibs on her serving her sentence in Idaho first. So once those crimes in the charges in Arizona are adjudicated, she'll come back to Idaho. If in the meantime they grant her a new trial in Idaho, then she would be brought back, and comically enough, she would go back to county jail. So that would be an interesting little twist too. But yeah. Polio. Any news on how Lori's doing in prison? We haven't heard a peep. I was listening to her brother, Adam Cox, and Uncle Rex Connor's last podcast that they've been doing. And somebody asked them whether or not either one of them had seen Lori in prison or whether they would. As to whether they would, they were both a little bit unsure, but neither one of them had any contact with her yet, even by phone. They said they believed that her mother, Janice, was talking to her on the telephone. But it's important to remember that sometimes during that intake orientation period, their ability to communicate with family or to have visitors is pretty limited. So we don't know how she's doing in prison. And I would suspect that she's not doing well. She's got some pretty severe mental health issues. She's in a completely foreign environment and still has more uncertainty hanging over her head. So if I were to guess, I'd say probably not too well. It's probably pretty miserable. Thank you, Terry. It was, my daughter was absolutely delighted. I took her wedding quilt uh, down to her for her birthday. This actually was a quilt that she found the pattern for and had asked me to make for her before we moved from Arizona. And I had it underway and then had to pack it up in boxes and figure out where I'd left off once we moved here. And admittedly, it took a long time to get to her. And she has been begging for me to finish it for a while. So she was very pleasantly surprised when it showed up on for her birthday. So I just took it down to her. In fact, I will get that picture pulled up and show it to you. It's across the back of her couch, and she sent me a cute picture of her cat laying on it and being very happy with her new quilt. So, and we're gonna, I'm still waiting to hear about whether or not we can use the crane pattern and the origami crane pattern to start a new project. So as soon as I know, I'll let y'all know. Hi, Julie. How in the world could you get an unbiased jury? At this point, Murdoch is known worldwide. It's true. However, I know that the trial was live streamed and that a lot of people tuned into it who don't typically watch trials, aren't your typical trial watchers. But I think that there are still very many people out there who don't know anything about the Murdochs. I think it's much more difficult in South Carolina than anywhere else, but they did find a jury to begin with, and I do believe that they would be able to find a jury to retry him. Just as we think they will be able to find a jury for Chad Daybell, even though the Vallow case has already happened here in Boise. So you'd be surprised at the number of people who are willfully ignorant about the news. If Lori's Arizona charges are upgraded to murder and she's found guilty, she could face the death penalty in Arizona. Would she still go back to Idaho? That's a really good question, and one that I don't absolutely know the answer to. I think some of it really would depend on the agreement between the states, and typically what happens is that the state that has the first conviction is where the person serves their sentence. However, if she were to be granted a new trial here and her conviction here negated, Arizona then could take priority. I'm not certain that the death penalty takes priority over a life sentence in another state. That's the question. I don't know. In general, I would say the death penalty would hang over her head, but it would not necessarily be the sentence that would be carried out first. So, good question. I'm not 100% sure. How can Jim represent these affidavits as true, but also say if these allegations are true? Okay, so let me see if I understand. When a person files an affidavit with the court, that person, the person whose name is on the affidavit. Now, oftentimes what happens is lawyers interview someone, draft an affidavit because they want to make sure that it meets all of the necessary legal points to support their motion. So the lawyer drafts the affidavit after having interviewed the person, and then that person says, yes, everything in that affidavit is accurate, and signs it. That is a sworn statement by the person making the statement. It is not a sworn statement made by the lawyer. So in this case, the affidavits were done by the jurors, and that is their sworn statements that they represent are true. Jim Griffin then takes those affidavits to the court and says, Judge, if you believe these affidavits, we're entitled to an evidentiary hearing where we're going to bring these witnesses in and they're going to testify in open court under oath before the public about what happened during their jury service. So Jim Griffin is not claiming the affidavits are true. He's saying, Judge, if you believe these affidavits, we get a new evidentiary hearing. That's the threshold. So the only thing he has to do is convince Judge Newman to schedule the evidentiary hearing, and then they get to bring in all their witnesses. Now, the burden is actually on the prosecution. The prosecution has to prove that it was a fair process and there wasn't any jury tampering going on. And so that, and we all know it's difficult to prove a negative. So this whole process is really an interesting legal exercise. In addition to being an exercise in whether or not Alec Murdoch gets a new trial, it also is kind of an interesting intellectual exercise as well. Any more questions, y'all? Well, in the meantime, while we're gathering up the last of the questions, I once again want to say thanks for coming and joining us here tonight. Thank you for the 450 odd people who joined us live. I appreciate you being here. I know that you have lots of other things you could be spending your time on, so I love the fact that I get to spend it with you. Please, if you have not, subscribe and hit the like button. Hit the notification bell, because we occasionally do, when big information comes down, go live at odd times. And join us next week. Next week, we'll do another recap. I'm sure that we'll have some more interesting things to talk about the Vallow and Daybell case, as well as Murdoch. But there are a lot of other interesting cases out there. We didn't talk at all about Corey Richens. We didn't talk about the Bahamas case, the Shiver case. So there's a lot more to wrap up. So remember that if you have questions and don't feel comfortable pointing them in the chat, or they come to you later, post them in our comments below or email them to me. If you have cases that you'd like to suggest that I talk about, please jot those down and get them to me in an email or in a comment. I know that a lot of people would like to hear us talk about Sarah Boone and about yet another attorney leaving her case. So we'll talk about that next time. And let me know if you've got other cases that you would really like me to look into. Don't forget, what are the penalties if Jim and Pootie are not truthful? Well, that's an ethical violation for which they could be disbarred, because being dishonest with the tribunal is a huge no-no and will be something that will get you disbarred quicker than nothing, quicker than anything, I guess I should say. So look for, within the next couple of weeks, some information about how you can get in on our raffle for the True Crime Quilt. And all of the proceeds from that will go to the Center for Missing and Exploited Children, which seems incredibly appropriate for what we do. So I want to say thank you so much for the super chats tonight. All of your super chats go directly to our moderator, Michelle, and I can tell you that she appreciates them more than you could know. I'm going to say good night and thank you so much for joining us, and I will see you next week.